On February 20th, 2026, at 10 in the morning, 6 justices of the highest court in the United States issued a ruling that shattered a presidency's signature economic policy. The vote was 6-3. The majority opinion was written by Chief Justice John Roberts, a conservative appointed by a Republican president. He was joined by 2 other conservatives, both of whom were appointed by the current president himself, and by all 3 liberal justices. 6-3. The ruling said the president did not have the legal authority to do the single most defining thing he had done since returning to office: impose sweeping trade levies on almost every country on earth. The levies had been in place for nearly a year. They had generated over $175 billion in government revenue. They had reshaped global commerce, strained alliances that had held for decades, and added roughly $1,000 per year to the cost of living for the average American household. And the court said none of it was legal, not some of it, not the way it was implemented, the authority itself. The president did not have the power, full stop. But here is where the story becomes extraordinary, because what happened next was not retreat, it was not compromise, it was not a moment of reflection. Within hours, on the same day, the president held a press conference at the White House and announced that he had already signed a new executive order, a 10% global levy on all countries, effective almost immediately, using a completely different legal authority. He did not wait a day, he did not consult Congress, he did not pause to address the $175 billion that had been collected under an authority the court had just declared illegal. He pivoted. Same day, same desk, different piece of paper. And then, standing behind the podium in the White House briefing room, he turned his attention to the justices who had ruled against him. 2 of them were people he had personally selected for the court. He had nominated them. He had championed their confirmations. He had stood beside them in the Rose Garden. And on this day, in front of the cameras, he said their decision was terrible. He said it was an embarrassment to their families. He said foreign countries that had been, in his words, taking advantage of America for years were now dancing in the streets. And then he thanked the 3 justices who had dissented, the 3 who sided with him, for their strength, their wisdom, and their love of country. The implication was unmistakable. The justices who ruled against the president lacked those qualities: strength, wisdom, love of country. This was not a legal disagreement expressed through proper channels. This was a public dressing down of the judicial branch of government by the head of the executive branch, broadcast live to every newsroom on the planet. Now, to understand the full weight of what happened on February 20th, you need to understand how we got here. Because this did not begin with a court ruling, it began with a theory that the president tested on his first day in office and then pushed further than any predecessor had ever attempted. The theory was simple. A law passed in 1977 called the International Emergency Economic Powers Act, known as IEEPA, gives the president broad authority to regulate commerce during a national emergency. The law was designed for specific crises: freezing the assets of foreign governments under pressure, blocking transactions with designated entities, responding to acute threats that required immediate executive action. It was never used to impose levies on imported goods. No president in the 48 years since the law was enacted had ever interpreted it that way. Until now. Starting in February 2025, the president signed a series of executive orders declaring national emergencies related to trade deficits and the flow of restricted materials across American borders. He used those emergency declarations to impose levies on Canada, Mexico, and China. Then, on April 2nd, 2025, a date the administration called Liberation Day, he expanded the levies to nearly every country on Earth. The rates varied: 10% on some countries, 25% on others, 50% on a few. The stated justification was that these countries maintained unfair trade practices, and that the trade deficit itself constituted an emergency. But the United States has run trade deficits for decades. This was not a sudden crisis. It was a permanent feature of the American economy being reframed as an emergency, because the emergency label unlocked a power that Congress had never explicitly granted: the power to set levies unilaterally, without a vote, without a hearing, without the approval of a single elected representative in Congress. And for nearly a year, that theory held. The levies went into effect. Revenue poured in, over $175 billion by February 2026. Global supply chains buckled. American manufacturers who depended on imported components saw their costs spike. Small businesses that imported finished goods watched their margins vanish. Retailers passed the costs to consumers. The average American household paid an estimated $1,000 more per year in higher prices. Manufacturing, which the levies were supposed to revive, actually shed 108,000 jobs in 2025. Factory managers across the country reported that the levies were a drag on their business, not a boost. Morale in the sector was described by industry surveys as very low. But the revenue was real, And the political narrative was powerful. The president framed the levies as strength. Removing them was framed as weakness. And for a year, no institution in America had the authority or the willingness to say otherwise, until the court cases arrived. In May 2025, a group of small businesses filed suit. Learning Resources Incorporated, a company that makes educational toys, argued that the president did not have the authority to impose levies under IEEPA. The case was joined by dozens of other businesses, and eventually by a coalition of state governments. In May 2025, the United States Court of International Trade unanimously ruled that the IEEPA levies were illegal. In August 2025, the Court of Appeals upheld that ruling. And in November 2025, the highest court agreed to hear the case. Oral arguments were held. And on February 20th, 2026, the decision came down, 6-3. Chief Justice Roberts wrote for the majority. His opinion was direct. He said the president had asserted extraordinary power to unilaterally impose levies of unlimited amount, duration, and scope, and that no statute gave him that power. He wrote that when Congress grants the power to set levies, it does so clearly and with careful constraints. It did neither here. He invoked what legal scholars call the major questions doctrine, the principle that when the executive branch claims sweeping authority on a matter of enormous economic and political significance, it must point to clear authorization from Congress. The president could not, because IEEPA does not use the word tariff, it does not use the word duty, it does not use the word levy, it does not use the word tax. It authorizes the president to regulate importation, and for 48 years, every administration understood that to mean regulating transactions, not imposing charges on goods. To understand why that distinction matters, you need to understand where this law came from. IEEPA was passed in 1977 as a reform. Before it existed, presidents operated under the Trading with the Adversary Act of 1917, a law designed for periods of conflict. By the 1970s, presidents were using that conflict-era authority for peacetime economic actions, and Congress decided that was too much unchecked power. So it created IEEPA as a more limited alternative. The law was explicitly designed to constrain presidential authority, not expand it. It said the president could declare emergencies and regulate transactions, but it built in reporting requirements to Congress. It required the president to explain the emergency. It was meant to be narrow, temporary, and supervised. For nearly 5 decades, that is exactly how it functioned. Presidents used IEEPA to freeze assets of foreign governments, to block financial transactions with designated entities, to impose economic restrictions on specific regimes during specific crises. It was never, in 48 years, across 10 presidencies, used to impose a percentage charge on physical goods crossing the border, because the text does not say you can, and every prior administration knew that. The current administration made a different bet. It bet that the phrase regulate importation was broad enough to include setting prices on imports. It bet that no court would strike down a policy generating hundreds of billions in revenue. It bet that the political momentum of the levies, framed as patriotic, framed as strength, would make the legal challenge irrelevant. For a year, that bet paid off. The levies stayed. The revenue flowed. The courts issued rulings against the policy, but those rulings were stayed pending appeal. And then, on February 20th, the bet lost, 6-3. The highest court in the land, including 2 justices the president had personally placed there. Justice Elena Kagan, writing separately, put it even more plainly. She said, IEEPA gives the president significant authority over transactions involving foreign property, including the importation of goods. But in that generous delegation, one power is conspicuously missing. Nothing in the text, nor anything in its context, enables the president to unilaterally impose levies. And without statutory authority, the president's levies cannot stand. 6-3, 3 conservatives, 3 liberals, united on a single principle. The Constitution assigns the power to set levies to Congress, not to the president, and no emergency declaration changes that. Now here is where this story splits into 3 parallel consequences that most people are not seeing. The first is the refund question. Over $175 billion was collected under an authority that the court has now declared illegal. That money came from importers, American businesses that paid those charges at the border. Many of them passed the costs on to consumers, but the money was collected by the government. Justice Kavanaugh, who dissented, warned in his opinion that the government may be required to return billions of dollars. He called the situation a mess. The court itself did not address refunds. It sent the case back to the lower court to figure out how. The president, asked about refunds at his press conference, said it was not discussed in the ruling and predicted 5 more years of litigation. The Chamber of Commerce immediately called for swift refunds. Small businesses, the ones who brought the case, said they cannot afford to wait. One business owner said he had been in a constant state of worry since the levies were imposed in 2025. David Levi, the founder of a small educational products company called MicroKits, described what the past year had been like for his business. He said the levies had put him in a state of permanent uncertainty. Every shipment from overseas carried an unpredictable surcharge. Every pricing decision was a guess. Every customer conversation included an apology about higher costs. He said he could finally start growing his business again, but that he had a lot of catching up to do in 2026. The founder of a cycling company in Vermont said he looked forward to the government's refund of improperly collected duties. Nick Holm, whose company manufactures precision cycling equipment, said the ruling was a relief, not just for him, but for his employees in Burlington and at his production facility in Washington State. He said it would be many months before his supply chain was back up and running as normal. These are not multinational corporations. These are small businesses, family operations, companies with 10, 20, 50 employees who spent the past year absorbing cost increases they could not pass on, losing customers to cheaper alternatives, and watching their margins dissolve one shipment at a time. And the trade group that organized their lawsuit, We Pay the Charges, immediately called for a full, fast, and automatic refund process. Their executive director said, "Small businesses cannot afford to wait months or years while bureaucratic delays play out. They cannot afford expensive litigation just to recover money that was unlawfully collected from them. But the mechanism for returning $175 billion does not exist. No process has been created, no timeline has been set, and the administration has signaled it does not intend to return the money voluntarily. That is consequence number one. Consequence number two is what happened within hours of the ruling. The president signed an executive order imposing a new 10% global levy under a different law, Section 122 of the Trade Act of 1974. This provision allows the president to impose a baseline charge of up to 15% for no more than 150 days to deal with large and serious balance of payments deficits. The Treasury Secretary stated publicly that using these alternative authorities would result in virtually unchanged revenue in 2026. In other words, the administration's message to the court, to Congress, and to the American public was, you can strike down the legal basis, but the policy does not change. Same revenue, different box. Justice Kavanaugh, in his dissent, had essentially previewed this outcome. He wrote that the court's decision might not substantially constrain the president's ability going forward, because numerous other federal statutes authorize the president to impose levies, albeit with a few additional procedural steps. He even listed them. Section 232 of the Trade Expansion Act, Section 301 of the Trade Act, Section 338 of the original 1930 legislation. He wrote that the court had concluded the president checked the wrong statutory box, and within hours, the president checked a different one. But here is the critical detail that most coverage is missing. Section 122 has a hard limit, 150 days, 15% maximum. After that, the authority expires. The president cannot renew it unilaterally. He would need Congress to act, or he would need to invoke yet another statute with its own procedural requirements. Section 230U, which is already being used for steel, aluminum, automobiles, lumber, and semiconductors, requires a Commerce Department investigation before it can be applied to new product categories. Section 301 requires a formal investigation by the trade representative, including public hearings. These are not overnight tools. They take months, and they are subject to legal challenge at every step. So what the president signed on February 20th is not a permanent replacement. It is a bridge, a 150-day bridge. And the clock started on February 24th, which means by late July 2026, the administration must either have new legal authority in place from Congress or from completed investigations, or the baseline levy disappears. And that leads to consequence number three, the global reaction. Every trade deal the administration negotiated over the past year was built on the foundation of IEEPA levies. The European Union agreed to a 15% rate as part of its deal with the United States. China's effective rate was reduced from over 100% to around 30% through a series of agreements. Canada, Mexico, South Korea, Japan, Brazil, India all negotiated their positions relative to the IEEPA rates. Those rates no longer exist. The legal foundation beneath every one of those deals has just been pulled away. Canada's trade minister immediately issued a statement saying the ruling reinforces their position that the IEEPA levies were unjustified. The European Union said it was carefully analyzing the ruling. China issued a measured statement noting that trade disputes benefit nobody. South Korean analysts noted that even with a new 10% rate, major exporters would be paying less than before. And Mexico's president said that despite everything, all the rhetoric, all the pressure, Mexico had actually ended up in a relatively privileged position. The power dynamics have shifted. Countries that spent the last year negotiating from a position of weakness, accepting rates they considered unfair because they had no legal recourse, now know that the legal basis was invalid all along. They paid. The court said they should not have had to, and the replacement authority expires in 150 days. That is an enormous amount of leverage that just changed hands. Now step back and consider what this means structurally. The Constitution of the United States assigns the power to set levies on imported goods to Congress. Article 1, Section 8. That power has been delegated to the President through specific statutes, each with defined limits, procedures, and oversight mechanisms. IEEPA was never one of those statutes. The court has now confirmed that. But the President's response, signing a new order within hours, invoking a different law, declaring the revenue will not change, sends a message that the legal mechanism does not matter. Only the outcome matters. And that raises a question that goes beyond trade policy. If the executive branch can lose a landmark case at the highest court in the land and reimpose functionally the same policy the same afternoon, using a different legal box, what does judicial review actually constrain? This is not a partisan question. It is a structural question about how the American system of separated powers functions when one branch treats court rulings as obstacles to route around rather than boundaries to respect. The President said at his press conference that the justices who ruled against him actually increased the power and flexibility presidents have to impose trade restrictions. He framed the loss as a win. He framed the rebuke as an expansion of authority. And he may be right in the short term, because the alternative authorities exist. Section 232 has been upheld by courts. Section 301 has been used for decades. Section 122 has never been tested at this scale, but its text is clear. The President has tools, but each of those tools has limits that IEEPA did not. Time limits, scope limits, procedural requirements, congressional oversight. The era of unlimited, unchecked, emergency-based trade policy is over. What replaces it will be slower, more contested, and more visible. And that is the real consequence of February 20th. Not that the levies disappeared, they did not. Not that the President backed down, he did not. But that the legal architecture of American trade policy, the rules about who can do what and under which authority, has been rewritten by the highest court in a single morning. And every trading partner on earth, every business that imports goods, every consumer who pays higher prices, and every member of Congress who has been content to let the executive branch handle trade unilaterally, all of them now operate in a different legal reality. The 150-day clock is ticking. The refund litigation is beginning. The trade deals are destabilized. And the question of who actually controls American trade policy, the President or Congress, has been answered by the court. Congress. Whether Congress accepts that answer or continues to delegate it away is the story of the next 6 months. And here is the part that should concern everyone, regardless of where they stand on trade policy. For the past year, Congress has been largely absent from this story. The Constitution gives Congress, and only Congress, the power to set charges on imported goods. But for decades, Congress has delegated pieces of that power to the executive branch through various statutes. Section 232 for security-related charges, Section 301 for unfair trade practices, Section 122 for balance of payments emergencies. Each delegation came with limits. Each one was supposed to be narrow, targeted, and temporary. But over time, the executive branch pushed each authority further than it was designed to go. And Congress let it happen. Because trade policy is complicated, politically dangerous, and electorally risky. It is easier to let the executive branch make the hard decisions and take the blame. The court has now said there are boundaries. The question is whether Congress will use this moment to reclaim its authority, or whether it will pass new legislation giving the executive branch even broader powers to avoid the political cost of governing. Early signals are mixed. Some members of Congress celebrated the ruling and called it a victory for the Constitution. Others said nothing. And at least one prominent senator suggested that Congress should codify the levies into statute, effectively giving legal blessing to the policy the court just struck down. If that happens, the court's ruling becomes a speed bump, not a wall. And the principle that Congress controls trade, the principle the founders wrote into Article 1, becomes a principle that Congress voluntarily surrenders every time it becomes politically convenient. The founders did not give Congress the power over trade by accident. They did it because they understood that decisions affecting the economic lives of every citizen should be made by the branch closest to the people. The branch that can be voted out every 2 years, the branch that must answer to constituents who pay higher prices. That principle was affirmed on February 20th. What happens to it next depends not on the court, not on the President, on Congress, and on whether the people who elected them demand that they use the power they were given. If you want to understand how this reshapes the global economy and what happens when the clock runs out, make sure you are following this channel. Because this is not the end of the story. It is the beginning of a much bigger one.